Good afternoon and welcome. Today's webinar, Legal Considerations for Small Businesses, Look Before You Leap. And this webinar is sponsored by the SCORE Hudson Valley and Greater New York chapters. A little bit about SCORE, Hudson Valley and Greater New York chapters. Our goal is to foster vibrant small businesses through free mentoring and education. We serve our small business communities by providing confidential business mentoring, webinars such as this one and other workshops, extensive online educational resources. We support from startups to established businesses. Our volunteer business mentors have a wide range of industry experiences and areas of expertise to draw upon. And here for your reference is the list of the 9 chapters sponsoring today's webinar and their points of contact. How our webinar will work. Everyone will be muted during the presentation. Please submit your questions and comments using the Q&A function, not the chat. The chat will be disabled. We'll answer as many questions as possible after the presentation. You will receive a copy of the slides and recording approximately 24 hours after the presentation. Today's webinar is intended to raise your awareness of proper business legal practices and will be presented in a series of real-life client issues. The names are changed to protect the clients. We will cover how to avoid legal issues before they happen. There will be one mock story, and all participants will be asked to contribute their opinion as to which one that is. One participant will be selected from the pool to win a complimentary business consultation. Our presenter today, we're pleased to have Stephen Diamond, his partner in the law firm of Stenger, Diamond and Glass, LLP. He received his Juris Doctorate from Pepperdine University and a Master of Laws in Taxation from the University of Florida. He is admitted to practice in New York, Florida, and Massachusetts. His practice is primarily in the areas of estate planning and administration, business formation and transactions, real estate, bank lending, and elder law issues. He is the past chairman of and the current legal counsel to the Dutchess County Regional Chamber of Commerce, legal counsel for the Chamber Foundation, legal counsel for the Habitat of Humanity of Dutchess County and Ulster County, a 27th Northern Dutchess NAACP Freedom Fund honoree for justice, and a past member of the Board of Directors of the Community Foundation of Dutchess County, and a frequent lecturer on the topics of estate and retirement planning and elder law issues. He is a sitting judge in the town of Unionville and previously served his community as Assistant Chief of the Arlington Fire District. Without any further ado, I'm going to turn it over to Steve.
Bill, thank you, and welcome everybody.
Okay. So the first scenario, I signed this in a hurry without looking at it. What do you think?
Well, Bill, I think you should have come to me before you signed it, because one of the problems is we now have a signed agreement which is binding on the parties. One of the concerns I always have is little words sound alike but may have very different legal meanings. People very often will look at me and say, Steve, why are we using therefore, whereas, and all these other words that are normally not in our vocabulary? And the reason is many of these words have been interpreted by the court. So it's clear what they mean. If we use a different word that has a more current usage, it may not have been interpreted by the court. And rest assured, you probably don't want to be the person that has to get that word interpreted. I like to say court is a 5-letter word. So is money. And you don't want to spend your money on having to go to court. So it's imperative. Always, always, always have your documents reviewed by your attorney before you enter into it. I'd like to, those of us who are old enough to remember the Fram oil man. It was a TV commercial about a mechanic who used to hold up an oil filter and say, you can pay me now. And then he would point to an engine on the ground that was all dirty and oily, and he said, you could pay me later. So it's very important to have it looked at. I know it seems simple enough, but if you have somebody look at it for you, sometimes they catch thoughts that you may not have thought of, or especially if you're involved in the editing or authoring of that document, it's easier to overlook certain words because you wrote it, you know what you meant, and it may or may not say it. Can't tell you how many times clients have come to me that they've signed a lease, they want to get out of it. They signed a lease, it doesn't say what they thought it said. They signed a contract, it doesn't say what they thought it said. He shook hands with me, he said, don't worry. She said, don't worry, you don't need a contract, I'll take care of you. Don't do it. There may be an expense involved, but in the long run, that expense is much, much less expensive than having to go into court or having to try to renegotiate a deal that's already signed. There's a law that says once you have a signed agreement, you cannot introduce concepts and thoughts that were addressed in the contract inconsistently with what you think it should have said. The parole evidence rule doesn't allow it.
Okay. I printed this off the internet. How is it?
It's wonderful, but does it apply for what you need? You know, so often we see this with wills or powers of attorney, where people print things off and they use words that the form used, and of course it doesn't apply to New York state law. It doesn't apply to what they're talking about. Again, you may save money, but you're certainly not going to save, or you may save time, but you're not going to save money. It's nuances, little words are so important. And not only is it the words in the contract, but it's the experience behind the person who's helping you put those words on the contract. A lot of times, a client will come to me with terms to a transaction, and I'll be able to discuss them with the client, give him or her the advantage of my experience, and determine if it's really what they mean, or is there a better way of addressing this? Perfect example, client comes to me a number of years back and says, they have a business, they have a key employee, and they want to give the key employee a share of the ownership of the business so they can participate in the growth and the income. Pros and cons. One of the bad things about it is once you make somebody an owner, they have rights. And they have rights to say you as the owner are not carrying out business consistent with their interest, only consistent with your interest. An alternative to that would be the use of a profit sharing agreement that says every year, once we reach a certain profit amount, you're entitled to a share of that. And if we sell the business, you're entitled to a share of the sale of the business, or in the alternative, you're entitled to a share of the sales price. So you can accomplish what you want to accomplish, which is keeping the employee involved and interested, and at the same time, maybe having them be a part owner is not always the best interest. I always suggest if you want to become involved in a circumstance, it's best to have your attorney and your accountant on the phones and everybody talk together to make sure it's really what you want to achieve and in your best interest. I'm a firm believer that 3 heads are better than 1. And, I guess certain attorneys aren't as willing to participate in a group discussion, but I think it's very important. Printing documents off the internet because it looks like it's going to apply is probably not the safest and most efficient use of your time and your money and your protection. And I just want to remind people that times have changed, and especially with the internet. There's laws that certain contracts must be in writing. The statute of frauds. But understand, being in writing is not the same as it was even when I started practicing, which was we had a piece of paper, everybody read it, everybody signed it, and that was a writing. The courts have often interpreted email communications, email discussions to qualify as a written contract. No longer, as I said, no longer do you need the big piece of white paper with names at the end. If a person makes an offer and the other person accepts it on the internet and it identifies the parties, it identifies what the contract is about, it identifies the consideration or monetary benefit, and you may have a contract, even though you did not ever get around to signing a piece of paper. So just be careful. Just be very careful. Just like they say, never say yes to a stranger on the phone because you may have just bought something. Never say yes in an internet discussion because, again, you may be interpreted as having agreed to terms of a contract that may be binding. So just be very careful. And as always, anything you do on the internet has any significance, save. Every email I get from a client has any significance. Certainly, hey, Steve, are we closing today? That probably doesn't need to be saved. But anything discussing a contract, following up on a conversation or whatever gets saved into the directory of that client. So you always have a record of what you really did say and what you didn't say. And sometimes that does save your situation because you have written confirmation as to what the agreement was.
The check had my name on it, so I just deposited it.
When people go into business, there are different forms of business. You have the sole proprietor, this person that works by themselves. You have a partnership, that's two or more people working together. You have a corporation, and you have a limited liability company. Each has their pros and cons. The advantage of a sole proprietorship is it's easy. It's easy to get into. It's easy to create. You just file a DBA in the clerk's office, and now you're a sole proprietor. You get a tax ID number. You're off to the races, minimal requirements. You don't have to file annually with the state or biannually with the state. You don't have to file separate tax returns. You don't get taxed twice. So that's what the advantage is. Disadvantages, you have unlimited personal liability for whatever you do in connection with your activities. Now, it may be insurable, it may not be insurable, but it's unlimited personal liability. If you die, your business is terminated. There's nobody to carry it out. So when would you use a sole proprietorship? Well, I think if you have a iced tea booth at the front of your driveway, that may make sense because the dollar value doesn't justify a more formal formation. Perhaps if you can insure your liability so that you have no personal liability above except if you exceed your insurance policy, maybe that makes sense. A general partnership is basically the same concept, where it's two individuals, they have full liability, they agree to work together towards a common goal. The danger of a partnership is each partner can bind the other partner to a commitment. So even though, Bill, you may not know, we were partners and I bound us to a contract and you don't know it, you have equal liability to perform it. So very dangerous. The joint venture is when Bill and I work together, but we're not partners. We can't bind each other. We both have just different parts of the participation. A little safer, but again, in each of these cases, you have absolute full liability for anything that goes wrong. And as we all know, What can go wrong will go wrong. The next is a limited liability company. It's a little bit liability company or two more, well, it could be one or more people working together. It is a separate legal entity under the New York State law, so that if that entity provides services and there's an issue that comes out of it, only the assets of that entity will be subject to claim, and not the owner's individual assets. Now, there are exceptions to that. If you're a professional, a doctor, a lawyer, an Indian chief, you can't be shielded in liability from your own liability. But I have partners, and because we're a limited liability partnership, if they make an error, I do not have a personal liability. I'm only personally liable for my mistakes, errors, and omissions. But yeah, the advantage of the LLC is it creates a shield between you and your client or your customer or whatever they are, so that should something go wrong, you do not have personal liability, except the professional corporations. Now, there's certain expenses that you cannot shield. Workers' compensation claims against you. We'll talk about those in a moment, but they create absolute personal liability even if you're an owner. Limited liability companies can be taxed either as a corporation or as a partnership. So the tax structure you can pick. Limited liability company law gives members, which are the people that own the stock, limited liability company, less rights than in a corporation. The statutory protection for corporate members is better. Why do we like LLCs? Well, we talked about it because one, it provides protection against personal liability. It can be taxed right on your, if you're just sole owner, single owner LLC, it can be taxed right on your income tax, personal income tax return. You don't need a separate return. And, you know, the part with proper language, the company continue going, notwithstanding the death of one of its members. It also allows for ease of ownership transfer. So let's assume you have a investment piece of real estate. If it's owned by the LLC, you can transfer portions of that ownership to your families or wherever you want to transfer it to, but just by transferring the limited liability company ownership. If you don't have it in a limited liability company, you have it in your own name, then you're going to have to end up transferring the deed, which is more cumbersome, more expensive. And especially if you want to transfer ownership in accordance with your estate plan, and you want to give them their $14,000 a year you can give without a tax effect, actually it's 17 now. It's easier to give fractional shares of an LLC ownership than to give fractional shares of a deed every year, and it's much less expensive. The last is the corporation. Again, the corporation is a legal entity. There's two ways to tax a corporation. One is the C corporation, where all the income is earned by the corporation, and it pays income tax on its gains. And then if it distributes its profits, called dividends, to you, you pay income tax on it as well. So it creates a double taxation. But with proper planning, most closely held corporations will distribute enough income through salary and bonus to the shareholders to eliminate a tax on the corporation and on the person. Now, we have our entity set up. And again, this is not exclusive of all discussions on the topic, but just know that they exist. So now we have, let's call it a limited liability company. And you provide services or goods to somebody. And they make the check to Bill. They don't make it to Bill LLC, even though Bill is an LLC, and even though Bill provided the services as Bill LLC. But they give the check to Bill. And then Bill, in the construction of the house, decides to drive over the septic line, crushing it. Bill sells the house, the new buyers open up, and of course, within a couple of weeks, the fact that the septic line was crushed creates a noticeable difference in the pleasant nature of the house, as we have a little backup. So they go after Bill. Well, Bill says, don't sue me, sue my LLC. It's got nothing. And they say, well, Bill, we used to make the check payable to Bill, not Bill LLC. And you deposited into your account instead of the Bill LLC account. So you've disregarded your LLC's structure. And now we're going to ask the court to do the same. Since you did not honor it, why should we be stuck honoring it? So very, very important. Just make sure if you have a business and the LLC and the check comes to your name and you can't get it redone, deposit it into your entity so that you recognize the formation of the entity so that they can't say you did not follow they're just very, very, very common problem. And nobody's doing anything terrible. In fact, Bill reported on his income tax return because he took Steve's seminar 2 years ago and knows even though it was paid to Bill, not Bill LLC, he still had to put it on his income tax return. So Bill's benefit was it was convenient. Bill's detriment is he may have created personal liability for something that did not have personal liability. And that expands to if you have employees and they do something wrong, if it's in the LLC, all they can do is take the LLC and its assets. Whereas if you don't have the protection of the LLC, they can come after you personally, which is really where you don't want to be. Next slide, please.
Yes. Yes. Okay, they are independent contractors, not an employee.
This is probably one of the hottest topics. Client comes in and says, I just got a $100,000 bill for workers' comp. They said, I forgot to pay for workers' comp. And I said, I don't need to pay for workers' comp because they're an independent contractor. They're not an employee. Both the IRS and the New York State Department, has Department of Labor has articles online. New York State, it's dol.ny.gov/independent-contractors. And the IRS is irs.gov/business/self/employed/independent/contractor. That gives guidance. Now, what are the standards they look for? They don't look for what you call it, but it really comes down to whether or not, behavior. Does the company control or have the right to control what the worker does and how the worker does his or her job? The fact they only work 10 hours a week for you instead of 40 hours a week for you does not make them an independent contractor on that alone. They can be a part-time employee. So the important thing here is how much control does the parent company have or the right to control the workers? And how does the worker do his or her job? Does the company provide all the tools? I just had a roofing job done on my house. The one company uses its own employees. The other one does an RFP to 3 or 4 different contracting companies to see which one, what they'll charge for the work and when they can come. The difference is the first group work for the company. The company tells them where to be, when to be, what to do. The second group appears to be more independent because they establish when they'll show up, what they'll charge you, and if they'll show up. They have no obligation to be there. Also, look at the relationship. If you're an independent contractor and not an employee, don't forget what happens to you. Well, you have to pay your own share of the FICA instead of having the entity pay your FICA. You get no health benefits from the company. You get no retirement benefits from the company. You don't get time off. You don't, so you have to look at the actual factual relationship between the parties. You also look at things as, does the company provide the tools or does the independent contractor provide the tools? Does the company pay the independent contractor a stipend to acquire those tools? So you have to really look at it. And there's actually, and I don't know if I have it in front of me, but there's like a 23-point test that the IRS came out with years ago. Flipping through New York State. Again, the employer or employee can choose when, how, and where the person works, provide the facilities, directly supervise, set the hours, require exclusive services, set the rate of pay, require attendance at meetings, ask for oral or written reports, reserve the right to review and approve the work product, evaluate job performance, require prior permission for absences, and have the right to hire or fire. That's more consistent with the employee than the contractor. But again, it's so important to have the proper agreements and review what the other one has. And where we really run into trouble with this is if an independent contractor doesn't have workers' comp and they get hurt, it's going to come back up the chain to the general contractor or the subcontractor that hired the independent contractor. So it's very important to establish who they are and how they're covered by insurance. Next slide, please.
Okay, I have suffered significant losses due to shoplifting. So I installed surveillance cameras in my shop, including the restrooms and changing rooms.
Well, Bill, there's some people may cringe at that because, of course, there's certain places there's an expectation of privacy. We always recommend that if you have installed surveillance cameras in your shop, you have a sign advising not only customers, but your employees. Your employees have the right to know. Changing rooms, bathrooms, these are places where there is expectation of privacy. You can't be filming while they're getting changed, while they're using the bathroom. Can't do it. And obvious reasons why you would feel uncomfortable knowing somebody else was doing it. Well, at least most of us feel uncomfortable knowing somebody else is doing it. So be careful with that, put people on notice, and certainly don't have a camera where you may be filming somebody not expecting to be filmed with the expectation of privacy. The fact that they're shoplifting in the back of the store, which is not in the bathrooms and not in the changing rooms, well, shame on them. You have to come up with another arrangement to help protect against the pilfering in those private locations. I mean, a lot of places have employees that check you as you go in, or they require a key to go in so they can check for those things. There's no balancing of the value of cameras versus the loss of privacy. Next film or next tape.
Okay. I pay my employees in cash.
Steve, the problem is my clients or my employees want to get paid in cash. If I don't pay them in cash, they'll go somewhere else and get paid in cash. And I can't make any money if I don't have employees. Obviously, now, when we say pay in cash, I think the presumption there is there's no reporting of that revenue in their name. It's not like you give them a $200 in cash for their paycheck, and then they give, and you give them the proper recording showing the withholdings and everything else. It's undocumented payment to the employees. What can go wrong with that, he says? Well, the first thing is they turn around in 2 years and say, you never paid me. I've got a little 1099 tip income that shows up on my, or not 1099, but on my W-2. But the rest, I don't make hourly wage because you don't pay me. And Bill says, well, sure, I pay you. And Bill, you have any receipts? In fact, Bill, why don't we go into court and say that in front of the person with the black robe, that you have no receipts of ever having paid me, and that you didn't report my earnings on a W-2, and that you didn't withhold the proper withholding tax, and you didn't withhold the proper FICA withholding, and you probably don't have insurance on me, and you certainly don't have workers' comp on me. So what happens? Judge, he never paid us. He owes us all this money. And we worked hard, Judge. And Bill's it. Just not a good thing to do. One problem. Next problem, workers' comp. If your employers are not on your workers' compensation insurance and they get hurt, Bill, I got bad news. You're personally liable for their medical expenses. You're personally liable for whatever their injuries and damages are. There's no protection. Without workers' comp, there's no protection if you're a corporation or a limited liability company either. So using that to protect you does not shield you. And with cash, and I had one client who didn't trust his employees, so he made sure they signed receipts receiving cash. But of course, he didn't report it as compensation, he reported it as cash. So what happens? The employee says, I never got paid. The employer can't say, yes, you did, but I didn't give you the proper reporting because I'm hiding it from the government. Another problem in today's society is real, is we are losing our cash economy status. So the employer may have income on the books, but then pays in cash, you won't be able to write it off. So he's got to pay income tax on your money instead of you paying income tax on your money. It's real. It's real. We talk about not having workers' comp, we don't have state disability. So many things can go wrong. And on the employee's point, the employee's not having any contributions going in for Social Security. Under Social Security, you have to work 10 quarters to be eligible for Social Security SSI, for disability insurance. If you don't work, you never earn the right to it. And then God forbid you do get hurt, the employee does get hurt. Well, you're responsible for their injuries. You're responsible for everything because you didn't have them in the system because you want to save a little bit of money. I don't know if there's any accountants in this group. You're all looking, shaking your head. Yes, don't do it. But you're also thinking about all the people that do it. I once had a client owned a deli. Or delicatessen if you're down Long Island. And he kept everybody on the books for 10 hours a week. Of course, I told him they have to keep them on the books for all their employment because that's what the law says. But he kept them on for 10 hours each. That way, if they ever got hurt, that was the 10 hours they were working that week. Not legal. Told him he can't do that. But somehow I think it fell on deaf ears and he ignored me. But, cash is king only when you don't have to account for it. Next slide, please.
Okay. Last one. I don't report all my income from my business.
Well, first, of course, for whatever reason, clients have a need to tell me that. Steve, there's 100,000 I'm getting, sale of a business, I'm getting 100,000 off the books. No, don't tell me that. I don't want to hear that. But no, don't tell me that. Because if I know about it, I can't allow you to do that. And that's a crime. And if I know you're about to commit a crime, I have an obligation to report it. Whereas if you call me up and say, hey, Steve, I sold my business last month and they gave me 100 grand cash. Well, now I'm your lawyer and I don't tell anybody because I'm protecting your interest. But if I know you're going to commit a crime, which in most cases, you know, tax fraud is usually a crime, depending on who you are. I got to tell you not to do it and not supposed to do that transaction. Have I ever had a closing on a purchase sale of a restaurant or other cash business where they don't excuse themselves to go to the bathroom together and come back and we finish the closing? Probably never, but you know, like, people get nervous buying big businesses and they have to go. Other problems with cash. One of the big problems is you've run your business and you've put a lot of the revenue in your pocket and not in the bank and not on your tax return. And a thing called COVID comes along and you want to file for the PPP money. But your income tax doesn't show any loss because you never showed any income. You don't get any PPP money. Now that's a one time in our lifetime, but that's what nature of the concerns. You go to sell your business. Buyer wants to get a loan. Bank says to buyer, hey, get us 3 years past tax returns. Not a lot of stuff on those tax returns. And the bank is not going to take the, well, he drives fancy cars, new fancy cars, therefore he must be making money mentality. So if you don't maintain a balance sheet and a profitability, if you go to sell, your borrower is going to have difficult time borrowing money. They're going to have difficult time establishing the profitability to justify the loan. And I can't tell you how many times I hear, you should see the cars he drives or she drives. She has to be making money. The auditors, you know, the federal, state, and federal bank auditors do not accept pictures of cars as proof of income. Doesn't work that way. And obviously some of the other problems with income is you pay your employees an income. We go back to the no workers' comp, no social security contribution. It may save money in the short run, the long run, maybe not. I've had a lot of clients come to me over the years and they start looking over their shoulders for everything. And they don't know when the next person knocking is going to be, you know, the tax collector coming in on them. It creates a lot of anxiety. A lot of anxiety. And how do you spend it? I mean, you can't put it in the bank anymore because the bank's reported everything over $5,000 or any suspicious deposit history. And now that interest rates are going up, keeping it in the coffee can, if you have it, they don't even have, not that much money you can fit into a little K-cup, you know. Not like the good old days when we had big pound or 2 pound cans of coffee. All issues you have to worry about. Bill, I think I used my 40 minutes up.
Okay, well, thank you, Steve. Very enlightening and very informative. So we do have a few questions here, and I'll read them off to you.
Okay.
What is the definition to independent for statement? They are an independent contractor, not an employee. So I guess it's what's the definition of an independent contractor is the question.
I don't know that there's a specific definition. You know, it's a facts and circumstances. I strongly urge you to talk to your accountant, talk to your lawyer, look at what you're doing. The title employee or the title independent contractor is meaningless. It's a facts and circumstances situation. What's the control you show over the person or they show over you? I hire somebody to do a deck and they come in, they put my deck up. Maybe that's an independent contractor. I hire somebody to put in a deck and I'm sitting there and watching everything they do and tell them what they do, and they order the wood and the supplies all on my credit card. And really, it's the facts and circumstances. And you have to really look at it. And are they really independent? Do they go out and put decks on for every builder in Dutchess County? Well, that probably makes them independent. If they're only doing decks for you, then they're probably not so independent. And it's more of an employee. It could be a part-time employee, but it's more of an employee. Are there those of us who feel more comfortable if the employee is an entity? An LLC or an INC? Well, you can't, a corporation cannot be a statutory employee. Not 100% protection, but a lot better.
Okay, next one. What if I want to hire someone overseas to conduct a technical review of my website just once? Do I still need workers' comp? They access the back end of my website virtually. They do not physically need to be in the same space as me.
Are they your employee? If they're your employee, you have to have the insurance coverages. Your ratings will be much less because it's a type, it's got a lesser likelihood of injury and severe injury than somebody who works on church steeples. But if you're an employee, you have to have it. If you're an independent contractor, you don't have that workers' compensation issue. And again, I think IT has a much lower level liability than somebody who's doing a more physical job around your yard. They're doing your fence, they're doing your wall, or things along that line. They're driving a vehicle. But again, facts and circumstances, go online, read the examples, and fit your people into it. Or again, call your attorney, call your accountant, and discuss what you're doing with them.
The next one, if you have an employee sign when paid in cash, doesn't that count as legally paid?
So you're going to pay in cash to avoid the law and then make a written receipt that you did it. Is that what you're saying, Bill?
That's what's basically being said here.
Okay, so now you do that, and then why didn't you do withholding? It's now you're admitting on paper that you're committing tax fraud. That's probably not my idea of a good idea. Oh, but good for me because I can defend you. But for you, not so good, Bill.
As far as an independent contractor not having workers' comp and it going to whomever hired the contractor, what about personal liability insurance? What's the difference?
Workers' compensation is a statutory creation for insurance that provides protection to employees who get hurt on the job. Your personal liability, an umbrella policy, probably excludes employees that are not casual employees. And casual, you'd have to look at your policy, but it's defined in very few days a year. I mean, if somebody's coming in one day to mow your lawn, he's probably, or provide, come in and paint your kitchen, you're probably not, he could be a casual employee. But if they come in and they work for you all the time, they're an employee, and if they don't have workers' comp and they get hurt, it's going to be on you. And if you don't have workers' comp on them, then they create personal liability on you. But you need to also know that in New York, if a person is doing work on a commercial building and they're doing work from an elevated position, there is absolute liability in the landowner if somebody gets hurt. And the defense of you're an employee does not work. So you have to be very careful of that. If they're working off the ground, elevated, you have to be careful because New York has lots of liability traps there. And certainly if you have a contractor working on the project, the contract says they shall provide you proof of the following things. And one of those things is workers' comp by the employees and any subcontractors.
Next, how about using a virtual assistant as a LLC?
I'm not sure I even know what that means.
Nor do I.
Perhaps they're asking, well, what if I use a virtual assistant? What is my liability as them being an employee? I
Could be.
don't know,
Yeah.
maybe, yeah. Certainly the fact that they're virtual or, or telecommuting and not working in the office does not change your obligation to have the proper employee taxes. If they're an independent contractor, maybe, but certainly, again, you have to look at facts and circumstances. Do they work for you every day, 8 hours a day, virtually? It doesn't change the fact they're then an employee.
What are the basic legal documents needed to launch an online website that sells products like jewelry or small household goods? Issues such as terms and conditions, cookies, privacy policy, for a small business that operates in personal, occasional, and online sales, and sells only within the United States. So it's
That's kind of a more specific question, Bill, that I think we need to copy here. Certainly, if you're doing online sales, you have to make sure you comply with the, there's lots of rules and regulations for online sales. It depends how, what you're selling.
right.
I mean, certainly if you're selling, I have clients that sell drink remedies or health foods and different, and those are all regulated by health department. It depends whether or not you're selling products that you create or you're just combining products that already have approval. So there's a lot of, it really depends a lot on what you're doing. As far as what you need to do, certainly you're going to want to have an entity formed. You're going to want to make sure you have the proper liability insurance. You want to make sure you're not violating anybody else's protection and make sure you're not violating a minimum pricing rules. You have to go back to how you're buying the products and find out what rules they operate under.
Okay. How can I access a lawyer who deals with my book business? I find it difficult to remember the proper name for that category of attorneys.
You sell
And I sell books.
book. Oh, I thought they meant bookies.
No,
My bad. I mean, if you're looking for a copyright attorney, it's probably, if you're looking to protect the content, you're looking for a copyright attorney. Somebody will protect your written material. If you're looking to protect the name, it's a trademark attorney. Certainly, if you're looking to protect the mechanical process, it would be a patent attorney. But basically, I think the general rule is if you ask for an intellectual property attorney, they will usually cover all those items.
Right.
And while you're doing it, and you're using a name, you got to make sure your name's not used someplace else. Because then someone's going to send you a nasty gram saying you're using my name, you can't use my name, and then you run into problems. So.
Okay. As a homeowner, do you have protection if you hire and pay via cash or Zelle to day laborers if they get hurt on the job while doing work at your house?
Again, if you're casual laborers, you're probably protected. You're not protected for not filing the wage and hour laws, meaning if you give them cash, they come back and say you never paid them, you may have a problem. You have to, of course, if you're employing somebody, you have to make sure they have the proper credentials to work in the United States. You can still be charged with employing a person who is not legally allowed to be here. So you have to have make sure they have the proper proof that they're allowed to work.
I think that is pretty much it, Steve.
Well,
Thank you for taking the time.
Oh, you're welcome. I just want to remind people it's good to have a relationship with an attorney. You know, and it's good to have a relationship with an attorney who you feel comfortable talking to. And who gets back to you, there's nothing wrong with saying I can't have an appointment for a certain period of days, weeks, or months, but you also want somebody that gets back to you, at least acknowledges that you're contacting them and picking a time, date, or place in the future to set a time to talk about these things. And another very dangerous thing is let me just run a question by you. Well, half the times those questions are inartfully worded, not anybody's fault. It's just their specific questions. It's done on the fly. It's done at a cocktail hour, ballpark setting, a barbecue, and all the facts. It's not saving you time and money to just get that quick answer in the long run. And if a problem develops, you're going to look to your friend and say, hey, you told me. And the person say, we had a discussion at a barbecue. I didn't tell you. So, it makes sense to do it the right way. Formalize it. Everything should be in a formalized manner. I know it's a little more expensive. I know it's a little slower. But again, the stitch in time will save 9.
We did have a couple more quickly pop in
Okay.
here. What kind of attorney should I look for to advise me on what I need to start my business? I don't know what they are called. There are so many lawyers out there.
I would just an attorney that practices business law. I would suggest that you talk to friends and accountants and family that may have a business and ask them who they use. I don't like picking my eye doctors, my dentist, or anybody else out of the internet just because they have a big ad. So I think you just should do a little bit of research and, give Bill a call and see what he's heard about the person. I mean, he deals with a lot of professionals in our local community, and he'd tell you, I'm sure he's a gentleman who would never speak ill of somebody, but other people have, and don't forget, every attorney's different. Not only do they have to have the skill, but they have to have perhaps the bedside manner or the personality to make you comfortable working with them, because the best attorney you don't call won't help you. I think I'm done, unless Bill has anything more for me.
Yeah,
We got another one.
no. So we're at the point, folks, where we said that we would put everything up here. These are the 7 scenarios that Steve went through. And so we need to pick out 1 through 7. Which one was the mock or the fake scenario? The rest were all actual transactions or situations. So the poll is up there. So go ahead and vote. And from the list of folks that come up with the right answer, we will randomly select one person, and Steve has offered to provide a free business consultation. So go ahead and vote.
Just letting
Which one was the mock or fake scenario?
Just letting a few more people vote here, seeing them come in.
Well, 52% of the folks got the answer right. Was
Looks
number
like I got
5.
outed, Bill.
Pardon?
Looks like I got outed.
Yeah, you did. Wow, boy, they snipped that one out. Well, congratulations.
Let me tell you a real funny anecdote about filming. Client of mine's opening up a new business, and he has no family members working in it. So he says, Steve, what I'm going to do is cash business, partially cash, mostly cash, whatever. I'm going to get a video system that takes a picture of the cash register and the till to make sure when people ring things up, the money goes in the till. And I said to my client, well, why don't you just stream that right to the Internal Revenue Service? Because, of course, you have to put all your cash in the till. So he just kept the camera just on what got rung up, just on the till to make sure things went in and didn't get lost. But yeah, so always run it by somebody who does it. We think lawyers, We become very cynical people. We think of things that are wrong when nobody else sees them. It's a terrible way to have life, but it's what happens.
And thank you very much, Steve.
Thank you, Bill.
And we greatly appreciate all your valuable information. My screen froze, unfortunately. There we go. Next month's webinar topic will be social media marketing, the top 3 things to do now and the 1 thing never to do. And that webinar will be on Wednesday, July 19th at 1 o'clock. Thank you all for attending this afternoon. And again, thank you very much, Steve. Greatly appreciate it.
Thank you.
Again, we're funded by the SBA. Have a great day, everybody, and we'll be reaching out and contacting the person that will randomly select as the winner. So, thank you very much.
Thank you, Bill. Thank you, Raquel, and have a wonderful day.